will ensure that the assets are distributed in a similar fashion. Over here again, will is a matter of dispute, which means again, in case anybody who is not happy with the way she's distributed assets, or anybody who wants to lay a claim on her assets, external, extended family members, etc., can put a claim on the will, right? And hence the execution of will could be a court-driven process, and hence an order, injunction of that is a practical real-time example, right? Which can happen with any family, right? Third option available, as you were exploring and you wanted to know about HUF. HUF currently was earlier erstwhile was being used as a succession tool as well, and wherein all families would hold assets together. But in the current scheme of laws, people are not using HUF as a succession vehicle. A few reasons associated with it, because it's a Hindu undivided family, right? Which means everybody who is now your family has a share in that HUF, right? Which means even when we're talking about your spouses, Purva sir, more specifically to you, your wife automatically, by the virtue of being married to you, will become a member, whether you write her name or you don't write her name. Just because she has that marriage certificate, she's a member, and a member has equal right on the HUF assets. It's just that she can't ask for a share, but whenever the HUF assets will be distributed, she has an equal right. Okay. So, and also to say that India is moving towards uniform civil code. Currently, this is being, it has not yet been enacted. But whenever India will enact a uniform civil code, which means the religious laws will go away, at that point of time, HUF will also cease to exist. Right? Akshay sir, from your perspective, HUF is an unknown territory from the US tax standpoint. They generally tax it like a partnership, which means you are a partner to the HUF, which could become tax unfriendly to you. Right. Now coming to the next option is a trust, right? Often families who face certain challenges, or in case who have certain specific objective, look at trust as a specific solution, right? Which means like in case your mother were to create a trust and she transfers the assets to her assets to the trust today, the trust would be the owner of the trust of those assets, right? In the trust document, it is her wish how she wants the trust mechanism to work beyond her passing away. During her lifetime, she can enjoy the assets in case she wishes to, beyond which she can mention that how the assets should pass on to the next generation, which means your generation as well as the grandkids, right? Now, the beauty of the trust is while will gives immediate access to wealth to both of you all, which means अगर उन्होंने will में लिखा है कि उनके बाद सब कुछ आपका होना है, assets will be transmitted to your accounts, which means Apurva sir, in your particular case, you inherit all your wealth, and in case you were to file a separation in the court of law, then anything and everything that is reflecting in your net worth will technically open to claim. Right? And hence it's important that you do not own too many assets in your name in case you are forcing such a situation. Right? Which means you definitely should not inherit direct assets from your mother, because that will just add up to your net worth. Right? And hence a trust structure in place, which means even beyond your lifetime, the trust continues to own the wealth. You are just a beneficiary along with the grandchildren in the family, your brother, etc. But you alone do not have access to the wealth, which means money can be made available to you basis how it has been defined in the document. Okay. Akshay sir, from your standpoint, you being a US tax resident, that brings in additional US tax complications, right? So whether or not you would want to inherit direct assets from your mother, which US estate duty implication in case your total worldwide net worth is above that given threshold. The given threshold is too large. It is around 13 million US dollars in case I'm correct with the numbers. But in case your net worth surpasses then that incremental wealth is exposed to US estate duty. So for you also, whether or not you should succeed your mother's asset is something that you need to think about. Another aspect is about your next generation, right? Once you inherit assets directly out of your mother's will, or in case your mother gives it today to both of y'all, in case something happens to y'all, then there is equal importance to your succession plan as well, right? क्योंकि अगर will के through आपके नाम पे पैसे हो गए और अगर आपने कुछ नहीं किया, तो obviously succession to your children will become a problem. In case you've put a trust structure in place, then which means that those assets are already taken care of for your children as well, which means apne children ke marital problem solve kar diye, that tomorrow in case they were to face a similar situation with the partner that they get married to, or they probably they get involved into some litigation, some dispute, etc., then at least this India corpus, which is basically inheritance from your mother, is protected for your children as well, which means we are talking about succession not only at your level, for your grandchildren also. Okay, so this is also one point, and hence what I see that a trust structure makes a lot of sense, right? Having said, the trust needs to be structured appropriately, and what all can be moved at what given point of time, looking at your mother's age, what is the kind of assets that she's holding, whether it can be moved during her lifetime or through her will, etc. That is something that needs to be designed, and it becomes a part of our estate and succession planning exercise. Any questions so far? I've just been speaking and giving you information, so any questions so far?
So just one clarification. So for one of the points you said that because Akshay is US citizen, he will be considered partner. So that was in context of HUF.
Yes,
Okay, got it.
HUF.
Okay, got it. Thanks.
Yes. Sure. All right, sir. So the options I've told you, right? A will and a trust is something that should be structured for your mother's assets, right? In India, movement of real estate from an individual names to a trust will call for stamp duty, payment of full stamp duty again. Hence, in case your mother owns large real estate in Mumbai, then she can will it to the trust, which means the trust becomes the ultimate owner. However, in case you all as a family are of the view that mom ke baad you all don't wish to hold real estate and you all want to convert into financial assets, or you all want to liquidate the real estate during her lifetime, etc., right? Then that can be managed and that can stay out of the trust. The trust ideally can hold assets which you all wish to protect from any sort of risk, right? You'll wish to protect for the benefit of the next generation, right? Movement of financial assets to the trust is fairly easy, comes without any income tax implications also, right? With some families, what we have seen is that because you are two brothers and into separate jurisdictions, right? It's I'm to say it's between both of you all to decide. We've seen that in case you're looking at creating a trust, you all could have separate buckets, right? Because both of you all will have different objectives from longer perspective for your children. Akshay sir being in US, right? Whatever will be his portion, everything becomes reportable in the US. He also has to pay additional differential taxes in the US for the income earned in the trust also, right? So Arpurva sir, you might not want to expose your portion of the assets to US taxes, and hence separation at that level could also be something that you might want to think about. Okay, and these are just pointers because we've seen families think about it. You as a family unit might think differently. So please feel free to share your views. So it depends at what point of time. So like your mother In case she has absolute clarity कि मेरे दो बेटे हैं, दोनों को equal देना है, तो वो आज ही दो trust बना देगी and she will fund say 50 rupees in this trust and 50 rupees in that trust, or assets worth 50 here and assets worth 50 there, right? And that is how it is managed. And the trust is specifically designed for both of you, keeping your succession in mind. I'm to say, how would you want your trust for your children to work beyond your mother's lifetime? Because your mother's already 77, right? So more so, your inputs will be required. Akshay sir, because you are US exposed, right? हमें US tax laws ध्यान में रख के structure करना पड़ेगा. We will tell you about the US tax implications on the trust. To the best of our knowledge, we can involve a US tax counsel to give you more clarity in terms of, in case you need something in writing, etc. Purva, so for you, your trust should talk more about asset protection, about your spouse being an excluded beneficiary, or making it more watertight from that aspect, right? So from that perspective, it makes sense to have two separate buckets in case the family feels comfortable and in case there's clarity with what your mother actually wants to do. No, so we are not talking about three. Even in case we create two, we will ensure that your mother has full access to the assets during her lifetime. So it will be as if it's her money held in the trust account. She has first right of use, which means she can use whatever that she wants to from the trust. The balance belongs to you, so that she's also comfortable. Hmm. 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 No. So no tax implication, right? So in case you're creating a master trust today, right, which means your mother is moving assets from her name to the trust account, no tax implication at that point of time. Even when your mother passes away and the money in the trust gets distributed into your trust and Apurva sir's trust, right, no tax implication at that point of time. Okay, so there is no double taxes. You end up paying taxes only for the income that is being generated. तो अगर आपने मदर ने ट्रस्ट में इन्वेस्टमेंट कर रखी है उस पे
एक ही ट्रस्ट होता है. So then only for the benefits that Akshay get out of it, that shall have US tax implications, right? Not the
So
whole.
generally what happens, the entity gets reported in the US. Okay, the trust as an entity will get reported, which means Akshay sir will declare in a particular form that he's a beneficiary of a foreign trust in India. Right now, because he is a beneficiary of a foreign trust and his name reflects as a beneficiary, then the trust might have restrictions in terms of mutual fund investments, right? Because he might not want to pay additional TFIC taxes, right? When he is a beneficiary, there is another US tax issue. Those issues also. So, with US tax exposure, it brings in a lot of restrictions upon how the trust will function, what will be the role of Akshay sir, and how to optimize in the best way, so that US taxes obviously cannot be avoided but can be deferred.
Okay. So yeah, I wanted to be clear that why two trust, why not single trust?
Yeah, so this is the only reason, as I've told you, sir, to trust is because there is US tax exposure from one angle, and your corpus will also get exposed to the US, and the trust will need to follow certain principles in terms of
Okay, got it.
investments, etc.
Right. And do you see any merit in what Akshay was suggesting, three trust? Whether these two trust themselves they serve the purpose instead of having a parent trust and then two child trust like
So,
mother's
as
trust.
I mentioned, two trusts can solve the purpose rather than having three trusts, which is a parent trust and then two trusts. Because, as I mentioned, we will continue to involve your mother in both the trusts until her lifetime, which means she reserves the right to use the assets. She controls the assets as if it's her own money during her lifetime.
Okay, got it. And what is the like what's a how many minimum members shall be there in a trust? Whether single person can be the member or whether I need to bring in my daughter also in the trust? What is
So,
it?
yeah, so ideally speaking, bringing in your daughter makes more sense. Having your mother, yourself, and your daughter makes more sense, because then optically it can be shown that the trust assets do not solely belong to you. Okay, it is a group of people, right? And the discretion lies with the trustee, which means that your mother, until her lifetime, as to whom she wants to give the money to. She might decide to use the money for herself altogether. She might want to give everything to your granddaughter and not give you anything, right? Which means optically it is more protected from your perspective, because there could be a foreseen case of separation. तो अगर आप 100% beneficial owner हो, which means ultimately it is your money, right? But in case it's a group of people, then everybody has a right, but the percentage is not defined.
Correct. Okay, so it's not necessary that when a trust is formed, that time by interest of each beneficiary need to be defined. It can be kept open-ended also.
Yes, absolutely.
But then just theoretical question. So suppose if it is kept open-ended and then later on there is a dispute that who shall get benefited to what extent, then how that is handled?
So this particular decision lies with whosoever is appointed as a trustee, right? So beyond your mother's lifetime, whosoever will become a trustee. In case you choose any independent corporate trustee, then we will follow the guidelines of the mother, which she will leave in a side letter, जहाँ पे उन्होंने लिखा है that जब भी trust खत्म होगा etc. At that point of time, it is my wish that it should be equal, or it should be in this particular proportion. And as a corporate entity, as a professional entity, we will follow those wishes.
Okay, got it.
Right. Another point that I wanted to highlight is about real estate in Mumbai. Mumbai is still treated as a princely state by the erstwhile British laws that were created. So probate becomes mandatory when it comes to real estate. Okay. अभी ये थोड़ा सा टेक्निकल टर्म है. इसमें होता क्या है कि अगर रियल एस्टेट आपकी मॉम के नाम का है एंड जब भी ये विल एग्जीक्यूट होगी, right, the title doesn't move, right? The sub registrar will not know that your mom is no more, and in the will that she's written that the property is going to Apurva, Akshay, or their specific trust, right? For the sub registrar to update their records, they need a probated copy of the will, which means the executor of the will make a court application कि ये मेरी मदर नहीं है, उन्होंने विल में लिखा है कि ये प्रॉपर्टी ट्रस्ट को जानी है, ये प्रॉपर्टी बच्चों को जानी है, आप इसको प्रोबेट दीजिए. टू ग्रांट अ प्रोबेट, कोर्ट नीड्स NOC from family members, from legal heirs. They need you to publish a newspaper article, some notice in the newspaper, which will say that अगर किसी को इनके estate पे कोई claim है तो 15 दिन में आप reply कीजिए. Beyond that cooling period, and obviously the court takes its own time, say around 1 year, 1.5 years, they will grant a probate. The executor will take the probated copy to the sub-registrar, and that is how the title to the new owner will get updated in their records. Okay, so it's very specific to Mumbai, Chennai, and Calcutta in India. Delhi, Gujarat वगैरह में इन सब चीजों की जरूरत नहीं पड़ती है. But yes, this is an additional step which involves the court, which needs to be kept in mind. To avoid this, people feel that मैं आज ही ट्रस्ट को गिफ्ट कर देता हूँ या मैं आज ही अपूर्वा अक्षय को गिफ्ट कर देता हूँ मरने के पहले, राइट? देन यू आर बिकम एब्सोल्यूट ओनर्स, which means फिर अगर आपका सेपरेशन हो रहा है तो then that is your property, it is open to claim. For Akshay sir, that is your property, it adds up to your net worth in the US. This is really, yeah. यस, सो ट्रस्ट में डालोगे तो स्टैम्प ड्यूटी भरोगे, ट्रस्ट में नहीं डालोगे और बिल के थ्रू आएगा तो प्रोबेट का प्रोसेस कंप्लीट करोगे. या legal heirs, not all family members, legal heirs. So you and your brother, both of you are legal heirs. Yeah, but then it is open to claim because will के थ्रू आ रहा है तो कोई भी मांग सकता है प्रॉपर्टी फॉर XYZ रीजन. किसी ने चैलेंज कर लिया उस समय या तो फिर देन इट, yes, yeah, so obviously then there's an injunction, the court will not act until the matter is proven and resolved.
Okay, so just one sub question. So when we talk about the legal heir, so what I understand is that the grandchildren are also considered legal heir, right?
They are legal heirs, sir, but for all reasons, there are classes of legal heirs mentioned. ठीक है, तो पहला हक आपका बनता है बिकॉज आप डायरेक्ट बच्चे हो. अगर आप नहीं होते तो आपको रिप्रेजेंट करता आपका बच्चा.
Right. Okay, so it's not that means when I am around, तो ऐसा नहीं है कि I shall get 75% and my daughter shall get 25% by default.
नहीं,
Okay,
ऐसा नहीं.
got it, got it.
Yeah, so it's so right, absolutely. So this trust gives you enough and more flexibility, the way you want to structure it. I'm just saying, during your mother's lifetime, she has the right to make all the changes. She has the right to completely dissolve the trust altogether for any XYZ reason. Beyond her lifetime, to the extent that she wants to give flexibility in terms of amendments, right, that can be provided. राइट, आप चेंज क्या नहीं कर सकते हो कि आपने जिसको एक बार बेनिफिशियरी ऐड कर लिया उसको आप कंप्लीटली निकाल नहीं सकते. The trustee can decide to give less distribution as compared to the other, but they can't say that you are not a beneficiary anymore until specified. तो कोई cases में होता है जैसे अगर आपके बच्चे भी beneficiaries है trust के, right? Some people are not confident about how the children will grow up to, right? So in case the grandchild is found addicted to alcohol or any sort of drug abuse, then for that particular period they will not get any benefit interest and only the rehab cost can be borne by the trust, right? In case they are convicted of any crime, criminal ही बन गए, कुछ murder charges वगैरह, then they are not a beneficiary, etc. तो ऐसे cases में beneficial interest मना किया जा सकता है, right? But you can't disown a beneficiary completely. That cannot be changed. Yeah, right. Once she's identified somebody, then she cannot. She can choose not to give or give less, but she can't, only on the specified conditions they discontinue to become beneficiaries. तो ट्रस्ट डीड भी रजिस्टर करते हैं स्पेसिफिकली अगर ट्रस्ट में कभी भी रियल एस्टेट आएगा तो इट बिकम्स मैंडेटरी टू रजिस्टर द ट्रस्ट डीड एंड यस एनी अमेंडमेंट टू द ट्रस्ट डीड विल कॉल फॉर रजिस्ट्रेशन ऑफ दैट अमेंडमेंट आल्सो. Yeah, but in future, in case through the will you are going to accept real estate, then you have to register the trustee today. Yeah. Yes, sir. So I'm just saying, अगर आप register कर रहे हो trust deed, see, it's not mandatory in case the trust is only going to hold financial assets, but you foresee case में real estate आने वाली है, आप नया खरीद सकते हो, आपकी मॉम के will के थ्रू अगर real estate trust में आने वाली है, तो it makes sense that you register it today only. It can be done at a subsequent date also, but तभी it becomes a tedious process. Some sub registrars might ask you to show the balance sheet of the trust assets, right? अगर उस समय उन्होंने स्टैम्प ड्यूटी लेना चालू कर दिया ऑन द ट्रस्ट कॉर्पस जस्ट बिकॉज यू आर रजिस्टरिंग इट, देन इट्स गोइंग टू बी एन अननेसेसरी कॉस्ट. आज की तारीख में क्लैरिटी है, द ट्रस्ट इज जस्ट स्टार्टिंग, यू डोंट पे एडिशनल स्टैम्प ड्यूटी, राइट? हम आप सिर्फ रजिस्ट्रेशन कॉस्ट देते हो, 500 का 1000 रुपए का स्टैम्प पेपर लेते हो, दैट्स अबाउट इट, राइट? सो अगर ऐसा है कि ट्रस्ट को फ्लेक्सिबिलिटी चाहिए रियल एस्टेट एक्सेप्ट करने के लिए, तो देन इट्स मेक्स ऑल द सेंस टू हैव इट रजिस्टर्ड टुडे. यस, ओनली थिंग इज कि कल को अमेंडमेंट होगी तो वो अमेंडमेंट भी रजिस्टर करनी पड़ेगी. So for HNIs, UHNIs, they anyways end up paying taxes at the highest rate. ट्रस्ट का सिमिलर है, कैपिटल गेन्स, डिविडेंड टैक्स, ये सब कुछ सेम है इंडिविजुअल्स के लिए, लॉन्ग टर्म, शॉर्ट टर्म, ऑल ऑफ दैट इज द सेम फॉर ट्रस्ट इन्वेस्टमेंट्स आल्सो. द ट्रस्ट एंड्स अप पेइंग maximum marginal rate, which is the highest tax slab rate only for interest income. तो अगर आपने फिक्स डिपॉजिट कर रखी है उसके इंटरेस्ट पे आपको हाईएस्ट टैक्स भरना है. अगर रेंटल इनकम आ रहा है फ्रॉम अ प्रॉपर्टी ओन्ड बाय अ ट्रस्ट, उस पे आपको हाईएस्ट टैक्स भरना है. स्टैंडर्ड डिडक्शन इज अवेलेबल इन केस ऑफ रियल एस्टेट प्रॉपर्टीज. इसके अलावा टैक्स में expenses disallowed है, which means you cannot set off expenses against the income earned. So that is the only thing. And expenses होते नहीं है trust के, so except for tax. So yeah, so for your cases, I think it makes sense for you all to move the financial assets to the trust today only. आपकी मम्मी beneficiary रहेंगी, which means that any which ways, because she reserves all the rights and powers, trust में भी अगर कोई income generate होता है वो उनके level पे ही club होगा and she will file the taxes. ठीक है. The only advantage it brings is the situations, especially for Apurva sir, that he is in, क्योंकि I'm to say वो ऑलरेडी ट्रस्ट में सेटल्ड हो गया होगा, एसेट्स, एक लेगेसी क्रिएट हो गई होगी कि यू नो ये लार्जर फैमिली के लिए ट्रस्ट बनाया गया है एंड थिंग्स लाइक दैट.
So just for clarity, when we talk about the tax, तो वहाँ पे भी वो सेम इंडिविजुअल्स के जो डिफरेंट स्लैब्स रहते हैं, 5%, 10%, 20%, उस तरह से होता है या सीधा 30 से शुरू हो जाता है ट्रस्ट में?
सर कैपिटल गेन्स ही होता है, उसमें स्लैब नहीं है। ठीक है, फिर जो भी इनकम बचा वो आपकी
फाइनेंशियल एसेट्स है।
हाँ फाइनेंशियल एसेट्स, यानी इनकम कहाँ से जनरेट होगा, आपने इन्वेस्टमेंट्स कर रखी होगी।
ओके राइट या
राइट, तो वो तो कैपिटल गेन्स या डिविडेंड ही निकल के आएगा।
ओके
तो वो तो उसी रेट पे टैक्स होना है, फिर वो चाहे ट्रस्ट भरे या आपकी मॉम भरे।
ओके ओके
That is available in, yeah, that is available in your mom's account any which ways, right? अगर अभी तो न्यू टैक्स regime है, in case she is filing under tax regime, वो section 80C का कुछ मतलब नहीं है। But अगर old tax regime, I'm not even sure whether अभी from this year they'll be able to file under old tax regime and claim exemptions under section 80s. But अगर होता है तो yes, she can claim that, and the trust income is only reported as income from other sources. एंड जो भी उसमें कैपिटल गेन्स या डिविडेंड का टैक्स भर रहे हो वो भरना पड़ेगा, और अगर कोई किसी भी तरीके का इंटरेस्ट इनकम है तो उस पे हाईएस्ट टैक्स लग जाएगा।
So one follow-on question, not exactly about the tax, but somewhat related. अभी लेट्स से कुछ म्यूचुअल फंड कुछ शेयर्स है मदर के नाम पे, अभी मदर ने ट्रस्ट क्रिएट किया वेयर शी इज आल्सो मेंबर, और अपना जो जो भी वो ओन करती है उसको ट्रस्ट में ट्रांसफर करने पे मतलब वेदर इट वुड बी इक्विवेलेंट टू सी सेलिंग दिस एंड आफ्टर गेटिंग इनसाइड द ट्रस्ट शी इज बाइंग इट।
नो सर, it's not equivalent to selling it, it's just a transfer, it's just a gift। तो ट्रस्ट की बुक्स में जब ये एसेट्स दिखेंगे तो ट्रस्ट के बुक ऑफ अकाउंट में द कॉस्ट ऑफ एक्विजिशन विल बी द कॉस्ट एट विच शी एक्वायर्ड। तो जब भी ट्रस्ट बेचेगा तो उनको लॉन्ग टर्म कैपिटल गेन्स का बेनिफिट मिलेगा।
ओके या क्लियर। ओके तो अभी हाँ
ओके, सो दीज आर फैमिली ट्रस्ट और प्राइवेट ट्रस्ट। ओके, इंडिया में दो तरीके के ट्रस्ट एक्ट्स हैं। एक इंडियन ट्रस्ट एक्ट 1882 which is specific to this, and then there is a public trust act which talks about charitable trust, etc. So this is not a charitable trust, this is a private family trust. Yeah, it is the same in India as well. यूएस में उसको ग्रांटर ट्रस्ट एंड नॉन ग्रांटर ट्रस्ट बोलते हैं, इंडिया में रिवोकेबल इरिवोकेबल बोलते हैं। तो जो मैं स्ट्रक्चर आपको प्रपोज कर रही थी, दैट योर मॉम बिकम्स अ बेनिफिशियरी ऑफ द ट्रस्ट अलोंग विद यू सो दैट शी कैन एंजॉय हर एसेट, दिस विल क्वालिफाई टू बी अ रिवोकेबल ट्रस्ट इन इंडिया। बियॉन्ड हर लाइफ टाइम दिस विल ऑटोमेटिकली टर्न इनटू एन इरिवोकेबल ट्रस्ट। तो सो ट्रस्ट का खुद का या सो ट्रस्ट का खुद का एक अकाउंट क्रिएट होगा, देयर बी अ बैंक अकाउंट, देयर बी अ डीमैट अकाउंट, देयर बी अ पैन नंबर स्पेसिफिक टू द ट्रस्ट, राइट? आप अपनी म्यूचुअल फंड, मॉम की म्यूचुअल फंड इन्वेस्टमेंट्स अगर फिजिकल फोलियोज में है तो फिर वो हमें उसको रीमैट करके डीमैट करना पड़ेगा। सर्टेन एएमसीज आर नाउ अलाउइंग ट्रांसफर transfer of physical folios to trust accounts, I'm just saying the same format, no need of demat, but there are certain AMCs which have started to do so, not all. So that will depend. तो ये एक paper driven process हो सकता है for movement of asset of mutual funds which are not reflecting in the demat account. Demat account में जो भी है आपके मदर के, वो demat to demat off market transfer without tax हो सकता है. It's just a matter of signing the delivery instruction slip.
Okay, so one follow-on question, and then there are a couple of other points. So, in the interest of time, I think if we cover those, तो फॉलो ऑन क्वेश्चन ये था कि एक बार ट्रस्ट फॉर्म हो गया तो देन उसी टाइम पे ट्रस्ट का लाइफ भी डिफाइन करना पड़ता है कि ये फ्यूचर में जिस पर्पस के लिए बनाया था वो पर्पस अचीव हो गया, एंड एट दैट टाइम इफ माय मदर इज नो मोर, तो इफ यू वांट टू डिसॉल्व दैट ट्रस्ट, तो एंड इन
हाँ,
दैट केस I mean, whether that transfer of whatever assets are there in the trust from there to the individuals, because the trust is getting dissolved, तो उस टाइम पे और कोई टैक्स implication होगा?
ओके, सो आपके क्वेश्चन के अंदर से दो हिस्सों में डिवाइड कर लेती हूँ। हाँ, ट्रस्ट का हमें टर्म डिफाइन करना पड़ता है कि ये ट्रस्ट कब तक चलेगा, right? That can be defined in number of years, that can be linked to an event, which means upon your demise, upon your children's demise, upon your children achieving a certain age, etc., etc. तो इंडिया में perpetually trust नहीं चलती है कि generation to generation चलता रहेगा. You will have to limit it, ठीक है? तो दैट इज वन थिंग. सो वो टर्म डिफाइन करना पड़ेगा. जब भी ये ट्रस्ट का टर्म पूरा होगा, राइट, उस समय जो भी ट्रस्ट के एसेट्स उस टाइम के बेनिफिशियरीज को मिलेंगे, which means suppose both of you all are also gone and now there are your children living, right? So at that point of time the trust will make distributions to the children, okay, and at that point of time there will be no taxes, additional taxes, because ये सारा post tax paid पैसा उनको जाएगा.
Okay, got it. And now I thought that if you can cover one time approximate one time cost, recurring cost, and then in like what is the frequency at which returns need to be filed if at all trust is formed?
Yeah, so
Administration
trust,
aspect.
yeah, so the trust follows the regime of quarterly advance tax returns, right? तो वो quarterly advance tax returns trust के लिए फाइल करने होते हैं. ट्रस्ट के recurring charges वैसे कुछ ज्यादा होते नहीं है. It only comes in case you are appointing a professional corporate trustee, which means that अगर विस्ता जैसी एंटिटी को आप ट्रस्टी रखते हो तो फिर हम लोग डेफिनेटली फीस के लिए काम करते हैं. तो देन वी विल चार्ज अ फी that will be a subject matter of the corpus in the trust, ठीक है? तो हम स्लैब वाइज चार्ज करते हैं, हम परसेंटेज वाइज चार्ज नहीं करते. तो अगर किसी का कॉर्पस 50 करोड़ है तो फिर एक्स अमाउंट ऑफ फीस, किसी का 2000 करोड़ है तो वाई अमाउंट ऑफ फीस, राइट? तो दैट इज द वे द फीस विल बी डिफाइंड. Yes, there's a one time setup cost also. For drafting and executing one trust deed, our fees starts from 5.5 lakh rupees, provided it's a simple structure. In case there are additional complications, that calls for higher amount of fees, which technically, like in case we have to involve a US tax council, coordination with them, etc. So that is a higher fee.
Okay. और जो ट्रस्ट और अदर ट्रस्टी एडमिनिस्ट्रेटर, तो उसमें जैसे दो ऑप्शन है कि वन इज दैट इस तरह का कोई मतलब कॉर्पोरेट एंटिटी है जिसको बना सकते हैं, दूसरा है कोई फैमिली मेंबर तो बना सकते हैं. बट देन द क्वेश्चन इज दैट फैमिली मेंबर ऐसा होना चाहिए कि दैट पर्सन शैल बी अलाइव, तो shall not be too old as well as cannot be too young.
Yeah, no, family members की काफी challenges होते हैं when you appoint them as trustees, because firstly trustee एक ऐसा position है which can I'm to say अगर you know they are under some issues, right, them controlling a trust can call for scrutiny. तो अगर उनके ऊपर कोई EOW का नोटिस आ गया है और उनका नाम एज ट्रस्टी यहाँ पे रिफ्लेक्ट कर रहा है तो अननेसेसरी आपके ट्रस्ट तक वो पहुंच जाएगा. सेकेंड इज अगर कल को वो इंडिया छोड़ के NRI बन गए, यानी US जैसी कंट्री में चले गए, UK जैसी कंट्री में चले गए, विच अगेन taxes entities and individuals on the basis of control. अगर कंट्रोल दिख रहा है तो वो पूरे के पूरे ट्रस्ट को भी टैक्स कर सकते हैं, तो वो एक इश्यू हो जाता है. तीसरा, अगर वो ही नहीं रहे, विच मीन्स आपको उनकी सक्सेशन का भी सोचना है, दैट यू नो व्हाट इन केस समथिंग हैपेंस टू दैट पर्सन हु हैज बीन अपॉइंटेड एज अ ट्रस्टी, राइट? एंड फोर्थ इज बेनिफिशरीज के साथ उनका बनेगा नहीं बनेगा. वेल, एट योर जनरेशन टुडे they might be fine with you all, right, but your children might not like that individual, etc., right? So then there could be you know problems between the trustee and the beneficiary, which makes the trust a subject matter of dispute, right? So that is also one thing that we've seen. तो yes, individual अगर आप external family members वगैरह को trustee बना रहे हो तो you have to be really careful about these things, and hence people prefer having professional trustees जो अपना काम करेंगे in terms of due diligence, compliance, etc., and they will take away their own fees. They have no other vested interest.
Okay, got it. And also, like you told, you spoke about the quarterly, the advance tax, etc., whatever need to be paid. But apart from that, जैसे कंपनी का रहता है ना कि रिटर्न फाइल करना रहता है, तो उस तरह से इसका एनुअली वंस रिटर्न फाइल करना रहता है या क्वार्टरली रहता है या
तो क्वार्टरली एडवांस टैक्स रिटर्न्स फाइल होते हैं. सो क्वार्टरली हमें एडवांस टैक्स की कैलकुलेशंस वगैरह करके करना पड़ता है एंड फिर ईयर एंड रिकंसिलिएशन जैसे नॉर्मली इंडिविजुअल्स के लिए होता है वैसे ट्रस्ट के लिए भी होता है। कंपनी के जैसे कोई और बोर्ड मीटिंग्स या ऐसा और कुछ भी इसका कंप्लायंस नहीं होता है।
So there are two different things I think we are referring to. एक तो है आपका एडवांस टैक्स पेमेंट और दूसरा है आपका
ईयर एंड
रिटर्न
रिटर्न
फाइलिंग
फाइलिंग।
फाइलिंग
हाँ
ऑफ द
तो ईयर
रिटर्न
एंड रिटर्न फाइलिंग होता है,
सिर्फ
एडवांस
एक ही
टैक्स
बार साल
क्वार्टरली
में
पे
एक बार ही
करते हैं।
करना
हाँ
होता है।
राइट, रिटर्न्स तो एक ही बार फाइल करेंगे बट एडवांस टैक्स पे करेंगे, उसकी कंप्यूटेशन क्वार्टरली होगी एंड टैक्सेस भर देंगे बट फिर एट द एंड ईयर एंड फाइल होगा।
अब एक जस्ट वन थॉट अकर टू मी कि ट्रस्ट में उस तरह से भी पॉसिबिलिटी है कि इमूवेबल प्रॉपर्टी को बाहर में रखे और मूवेबल प्रॉपर्टी है उसको ट्रस्ट में डाल दे, वो सब पॉसिबिलिटी है। ऐसा नेचुरली नहीं है कि मदर का मतलब मदर का जो
कंप्लीट
भी
फ्लेक्सिबिलिटी।
एसेट्स है इट इज हर चॉइस कि उसको उस एसेट्स में से कौन से एसेट्स को ट्रस्ट में पार्क करना है, किसको बाहर रखना है।
एब्सोल्युटली।
ओके, अक्षय एनीथिंग यू वांटेड टू कवर?
So this is, yeah, the fees for this is for one trust, right? Any additional trust will call for additional fees. We generally do not charge 5.5 for the second trust. We discount the second trust because वो एक ही time का discussion हो रहा है, etc. So we will charge a discounted fee for the second trust. Okay.
तो एक आई थिंक
I'm from Mumbai. We have office in BKC and Andheri and Vikhroli, but I'm either in BKC or in Andheri.
मतलब इसका जूता आ गया।
आई थिंक वो एक लास्ट पॉइंट ये था प्रोबेट के रिलेटेड कि प्रोबेट एक तो व्हील के केस में प्रोबेट एक्चुअली इज एन इश्यू। तो अपार्ट फ्रॉम दैट मतलब वो प्रॉपर और कोई मतलब एचयूएफ या ट्रस्ट के केस में प्रोबेट का occurrence मतलब whether it comes into picture or it does not?
Sorry, sir.
मैं क्या बोल रहा था कि वो प्रोबेट है वो सिर्फ जब विल बनाएंगे तो विल को एग्जीक्यूट करने के लिए टाइम पे प्रोबेट इज मतलब रिलेवेंट और बाकी जो सिनारियोज है एचयूएफ या ट्रस्ट उस केस में प्रोबेट इज नो मोर रिलेवेंट।
या सो ट्रस्ट के एसेट्स के लिए प्रोबेट रेलेवेंट नहीं है बिकॉज ये एसेट्स आपके मॉम के लाइफ टाइम में गिफ्ट कर दिए गए हैं, राइट? सो इट इज वेरी वेरी आई एम टू से दैट ट्रस्ट सुपरसीड्स द विल, राइट? तो उस पे प्रोबेट एप्लीकेबल नहीं है ट्रस्ट के एसेट्स पे। इट इज ओनली फॉर एसेट्स रियल एस्टेट लेफ्ट इन योर मदर्स नेम इन मुंबई, चेन्नई, कलकत्ता।
ओके, तो अभी जस्ट एक मुझे आकर हुआ एक क्वेश्चन कि मुझे जो फॉर एग्जांपल आई एम राइट नाउ बेस्ड आउट ऑफ बेंगलोर, सो क्या कर्नाटका में क्या है कि इफ इमूवेबल प्रॉपर्टी इज गिफ्टेड तो देन आई थिंक देयर इज स्टैम्प ड्यूटी इज वेरी नॉमिनल, कुछ 1000 रुपीज ऐसा कुछ है। तो
राइट,
तो सिमिलरली अगर वहाँ पे मुंबई का जो प्रॉपर्टी है वो अगर ट्रस्ट को गिफ्ट करेंगे देन ऑल्सो पूरा स्टैम्प ड्यूटी देना है या
हाँ
चिल्ड्रन
पूरा
को
स्टैम्प
गिफ्ट
ड्यूटी
करेंगे,
देना है,
चिल्ड्रन को
राइट?
गिफ्ट
सो
करेंगे तो भी पूरा देना है?
सो नहीं, अगर आप रिलेटिव को गिफ्ट कर रहे हो विच मीन्स अगर आपकी मॉम आज गिफ्ट करती है आपको, मुंबई की प्रॉपर्टीज में रिड्यूस स्टैम्प ड्यूटी है बट वो नॉमिनल अंडर से 1 या 2% है, ओके, डिपेंडिंग अपॉन द रिलेशनशिप, ठीक है? बट अगर आप ट्रस्ट को गिफ्ट कर रहे हो बिकॉज ट्रस्ट देन बिकम्स अ एंटिटी, अंडर से ट्रीटेड एज एन एसोसिएशन ऑफ पर्सन, सो हेंस दे आर चार्जिंग फुल स्टैम्प ड्यूटी विच इज 6% प्लस 1% registration.
Okay, fine, clear. So Thanks for those valuable inputs. It provided us good insight into what are the different nuances involved. Thanks, everyone.
Yeah, so thank you,
Mhm.
Ashika, for all the. It was a good session for me too.
Yeah.
Yeah. So, sir, if you have any more questions, we can still discuss, and like if you want, we can set up another meeting as well in future if you want, right? And Neha, if you want to conclude something, and we can end the.
Yeah. So, sir, while Ashika has given us enough information, you can sort of process it. If you have any questions, we can reach out to Ashika again to clarify, and then we can move ahead. And in case in the meantime there is anything pertaining to investments, then of course Akshay and me are there to help you out.
Yeah.
Correct.
Progress. Sure, sir. Okay. Thank you, everyone. Thanks.
Thank
Thanks,
Bye-bye.
you.
everyone. Thanks,
Yeah.
everyone. Bye.
Bye.